So a federal judge just allowed the state of New York to get away with defying the Supreme Court's Bruen decision. And because of this, New York's ban on concealed carry just took effect. So let's talk about this. But real quick before we jump into this video, if you believe New York needs to stop violating our rights to keep and bear arms, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is Arms Directory. Arms Directory is the place to go for Second Amendment protected social networks and also for a marketplace. Feel free to post your favorite gun pictures, talk prices, find local events, and post videos about your new builds or your favorite builds in a place that actually supports the Second Amendment and is Second Amendment friendly. Right now, it's hard to find places that actually support the Second Amendment and allow you to talk about these types of things. And Arms Directory is providing a place where you can get together, talk about the Second Amendment, talk about the things you like in regards to firearms, and just be in a place that actually supports the Second Amendment. So if you're interested, I will leave a link down in the details section and the comment section as well. And thank you again, Arms Directory, for sponsoring this video. So like I said in the intro, a federal judge just threw out the case against New York and their new concealed carry law. GOA, or Gun Owners of America, sued New York because of the new concealed carry law, which they passed in direct defiance of the Supreme Court's recent ruling in New York State Rifle and Pistol Association v. Bruen. So in this lawsuit, GOA argues that in spite of that Supreme Court clear ruling in Bruen, the state of New York apparently did not get the memo. On the contrary, rather than representing a good faith attempt to bring New York and their law into compliance with that decision, the Concealed Carry Improvement Act, or the CCIA, was passed by the state of New York, and that essentially doubled down on their policies and created a scheme that's even worse than what existed prior to Bruen. Now, if you're interested in a more comprehensive breakdown of what the CCIA does, you can watch one of my prior videos, but just understand it creates a more restrictive application process, and then it makes it so that almost everywhere within the state of New York is a sensitive place, essentially making the permit, even if you get it, 100% useless. Because of how this law directly violates the Second Amendment and what the Supreme Court just said in Bruen, GOA sued the state of New York. In the lawsuit, GOA asked the district court judge for a preliminary injunction against the enforcement of this law, which was set to take effect on September 1st, today. Well, yesterday we got an order from that judge in this case, and what happened is he decided to dismiss the entire case. This effectively let the state of New York get away with defying the Supreme Court, and as a result, this new law took effect today. So let's break down what happened in this ruling, because it's insane, especially since the judge was only supposed to be ruling on the preliminary injunction, not on whether the entire case should be dismissed and thrown out. So the order of Glenn Sotheby, the judge in this case, reads, "For the reasons set forth below, plaintiff's complaint is sua sponte dismissed without prejudice for a lack of subject matter jurisdiction, and their motion for a preliminary injunction is denied without prejudice as moot." Now, what does that mean? Well, the judge here was reviewing the GOA request to enjoin the new law from going into effect before September 1st. That is what he was supposed to decide. Instead, on his own, i.e. sua sponte, he decided to dismiss the entire case because he believes the plaintiffs lack standing, and as a result, the entire case was thrown out by him. But then after dismissing this entire case, he then went on to analyze this new concealed carry law and said that, well, he would have granted the injunction and would have found that this law violates the Second Amendment and that Bruen decision if it wasn't for him throwing this entire case out. This was some really weird gaslighting going on by this judge, because he's saying, well, I've decided on my own accord to dismiss this entire case, but man, if I wasn't going to throw this case out, I would have ruled in your favor. Now, the main factor in which he dismissed this case on was the fact that he said there was a lack of standing by the plaintiffs. The judge states here, Plaintiff Antayuk was alleged and or sworn that he desires, wants, and wishes or would like after September 1st, 2022 to continue to carry a concealed handgun in all the places in which he currently carries it, which would violate the CCIA. But here is the wrinkle that the judge found. The judge says he has not alleged or sworn, however, that he intends to do so. The judge goes on to state that the plaintiff does not have to confess to his future violations by, say, calling the relevant local authorities and declaring his intent to violate the new gun laws, the sensitive location provisions, and the restrictions on locations by saying, I'm going to carry X amount of times this week at this location, at this time, on this date. He says he didn't have to do that, but he did say he must indicate his intent to violate the law. Here he has not. So let me sum up this insane position of the judge. He claims there is no standing in this case because the plaintiff here has not alleged in the complaint that he intends to violate the law, i.e. commit a crime. In this judge's eyes, you would have to get a plaintiff to claim that they intend to break the law for your case to even be heard. And since the plaintiff did not allege that he intends to violate the law and become a felon, there is no standing in this case, and therefore the judge went out of his way, sua sponte, on his own, and dismissed this entire case, and then said, well, the request for injunction is moot because I'm kicking this entire case. He then addresses that the plaintiffs might object that this ground for dismissal is one asserted in the defendant's pending motion to dismiss, to which the plaintiffs have not had an opportunity to respond, and essentially they were supposed to file a reply brief to that motion to dismiss, but it wasn't even due till September 6th. But then he says that the plaintiffs are respectfully reminded that they were given notice of this ground for dismissal in the opposition to the preliminary injunction, and they had an opportunity to refute it at the hearing on the preliminary injunction, but they didn't. Again, this is some weird next level gaslighting that this judge is doing, and really just amounts to him being a coward and trying to find a way out of ruling on this case. This is the judge saying, well, yeah, I know that this was something argued in the motion to dismiss, and you weren't even supposed to reply to that until September 6th. Your papers weren't even due till September 6th, but it was also mentioned in the opposition to the preliminary injunction. So if you really wanted to refute it, you should have brought it up at the hearing for the preliminary injunction. Again, this ruling from the judge was supposed to be on the preliminary injunction, but he bypassed all of that and decided, well, I'm going to rule on the motion to dismiss this case. I'm not even going to really address the preliminary injunction. But then even after all of that, he says, well, if I wasn't going to throw this case out under Bruen, you're right, plaintiffs. The good moral character requirement, the sensitive place restriction, the social media disclosures are all unconstitutional, and the CCIA should be struck down. But that's irrelevant, really, because he's dismissing this case. He stated, after carefully considering this matter, the court agrees with plaintiffs that the CCIA's definition of restricted locations impermissibly encompasses all private property in the state unless the property owner expressly permits the carry of firearms. He also stated that the CCIA reads less like such a measured response than a wish list of exercise inhibiting restrictions glued together by a severability clause in case some of the more fanciful restrictions were struck down. And because he agrees that the CCIA violates Bruen and the Second Amendment, he said he would have granted the preliminary injunction in favor of the plaintiffs, but too bad I had to find that there was no standing and I had to dismiss this case. So this was a really frustrating decision to read by this judge, because this judge went through mental gymnastics to ultimately decide to punt this case. One good thing with this order is that since there are other cases currently going on which challenge the CCIA as well, they can cite to this second part of the judge who found that he would have granted the preliminary injunction, that it was a violation of Bruen, that it is a violation of the Second Amendment. They can refer to that. And they can also hope in those cases that they will get an injunction from a judge who is not a coward and will actually rule and look at this issue. Now, I would suspect that this decision to dismiss the case will be appealed up to the circuit court. I don't have much faith in the circuit court, and I don't think that they maybe will decide this case the right way either. But I think because of that, this case is ultimately destined to eventually make its way up to the Supreme Court. And I think on review, the Supreme Court will not be happy for what's happening, the direct violation of their decision in Bruen, and also the express cowardice of this lower court judge and him trying to find any way out of actually doing the right thing. But in the meantime, New York's new concealed carry law took effect today because of this judge not doing the right thing. So that's what happened in this case. I know that there were a lot of people asking for a breakdown of that decision. Also yesterday, California and the SB 918 bill failed, which sought to create the same type of law in California. I'll be putting out another video probably tomorrow, breaking down that, discussing that further. So keep an eye out for that. There's a lot going on right now in the 2A space, so just bear with me. I'm trying to get to everything, and I will cover all these really important topics. So if you have any questions, go ahead and comment down below, and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algorit's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.